Welcome to the Foundations of the Criminal Justice System webinar, where I will be providing a brief overview and summary of the criminal justice system in Canada. The information provided in this workshop is not legal advice, but legal information only. This workshop will provide general information and is not meant to be used for specific legal matters. Please consult with a lawyer if you have questions about your specific legal matter. The objective of this webinar is to help folks develop a familiarity with the basics of the Canadian criminal justice system, provide self-represented litigants with access to legal education, and provide self-represented litigants with access to trauma-informed resources. First, we will review some definitions of some common terms people will hear during their criminal law matter. Next, we will review some legislation that someone will likely encounter and the types of offenses there are in Canada. After that, I will get into some things people should know about bail and their first court appearance. I will then review the pretrial process and common resolutions that the Crown typically offers in domestic violence situations. So first, we're going to go over some definitions of terms someone will hear or come across during a criminal matter. The Crown is the lawyer for the government and acts as a prosecutor in the case. They do not represent the victim in the case. Their purpose isn't to get a conviction, but to ensure the integrity of the criminal justice process is maintained. A judge is a public official who decides a case. Their purpose is to be objective and impartial when assessing a case to determine if someone is guilty or not guilty. Disclosure is the evidence that the Crown relies on to prosecute a criminal case. A person generally gets this package of information from the Crown sometime between their first and second court appearance. The disclosure is uploaded to a portal called Disclosure Hub. Once your disclosure is available, you will get a notification via email, and you need to create a login and password to access your disclosure. A criminal defense lawyer represents an accused person in their criminal matter. They defend the person being charged in a criminal matter. Duty counsel are lawyers who are paid by legal aid to support low-income people who qualify for their services. They assist a person on the day of their court appearance. For those who don't know, legal aid provides legal support to low-income individuals through their phone line, duty counsel, staff lawyers, through their certificate program, and their web-based information. You must call legal aid to see if you qualify for their services. The most common legislation that someone charged criminally will encounter is the Criminal Code. This legislation lists criminal offenses and describes under what circumstances an offense has been committed. It also outlines sentence ranges for offenses and whether an offense is an indictable offense, a hybrid offense, or a summary offense. There are three different categories of offenses in Canadian criminal law, and they are summary offenses, hybrid offenses, and indictable offenses. Summary offenses are considered less serious. The maximum penalty is 2 years less a day imprisonment and/or a $5,000 fine. Indictable offenses are the more serious offenses. Jail time is longer and fines are higher. There is also the option for a jury trial, whereas there is no option for this in summary offenses. Hybrid offenses give the Crown the option to proceed either summarily or by indictment. Next, I'm going to be talking about the arrest process. Someone gets arrested when the police see them committing a crime or the police have reasonable belief that someone committed a crime. Upon being arrested, it is very important that the person being arrested does not say anything to the police. They should speak to a lawyer before speaking to the police. Although most people have an impulse to speak to the police in an effort to defend themselves or explain why they shouldn't be charged, it is best for the person being charged to not say anything until they have spoken to a lawyer. When someone is arrested, they have the right to remain silent and not to speak to the police. The police can still try to talk to you. It is important to assert that you want to speak to a lawyer. If you are being arrested, it is really important to not say anything to the police. Any statements can be used against you, so it is best to speak to a lawyer before speaking to the police. Every person, regardless of what they are being arrested for, has rights upon being arrested. These are the right to a reasonable search, the right to remain silent, the right to speak to a lawyer, and the right to be told why you are being arrested. There is often confusion over whether police can search a person or not once they have been arrested. The short answer is yes, police can search you, but the search has to be reasonable. Police are allowed to search someone after they are arrested. The search must be reasonable and not unnecessarily intrusive. As an example, an arresting officer is allowed to conduct a pat-down search to ensure that an individual is not equipped with anything that could harm the officer or the public, or so that evidence is not destroyed. And just to reiterate again, you have a right to speak to a lawyer of your choice as soon as possible. The police must provide a reasonable opportunity for you to contact a lawyer without delay. The police must stop trying to obtain information from you until the right to counsel has been exercised or waived. So one of two things can happen after someone is arrested. The person can be released immediately under an undertaking with a promise to appear. On the other hand, the police can arrest someone and detain them in jail until they are granted bail. Sometimes police will release an arrested individual under an undertaking. If a person is released under an undertaking, they will receive a document called a Form 10 undertaking. This form outlines a number of very important information that the charged person needs to know. For example, it will have the accused person's first court date, the courthouse that the matter is out of, the date and time of the first court appearance, the date and time to provide their fingerprints and photographs at the police station, and most importantly, it will contain a person's bail conditions. And the bail conditions will outline any no contact orders or other conditions that the accused person must follow while their criminal matter is ongoing. If an accused person is not released under an undertaking, the accused must wait in custody until their bail hearing. If a judge grants the accused person bail, they are released with conditions they must follow. If an accused is not granted bail, they must stay in custody until their trial or until their matter is resolved. Bail hearings can be time-consuming and complex. The accused person, with the assistance of a lawyer, will need to create a bail plan outlining for the court where the accused person will live and how they will be supervised, among other things. They may also assign the accused person a surety who promises to supervise an accused person while they are out on bail. We will talk more about bail in the workshop on bail. Next, I will discuss some important dates that an accused person will have during their criminal proceeding. On the accused release papers, there will be a date, time, and location for their first court appearance. This first appearance is administrative in nature and is not a trial. Nothing regarding evidence or witnesses will be discussed. It is primarily for the court to get an update on what, if anything, has happened on the accused person's matter. Anything after the first appearance is called case management court or set date court. At your first appearance or case management court, you will appear before a judge or a justice of the peace who will give you some information, such as what you are charged with and an explanation of the charges and what they mean. They may also ask you if you qualify for legal aid, ask you if you have a lawyer, or if you have your disclosure. These are all common inquiries that will be made at case management court or at your first appearance. These appearances will be scheduled every 4 to 6 weeks until the criminal matter is resolved. Again, this is so the court can get regular updates on the matter to ensure it is moving along. Next, I will discuss some important dates that an accused person will have during their criminal proceeding. Once an accused person has their disclosure, a Crown pretrial can happen. A Crown pretrial is an informal meeting held between the Crown and the defense lawyer. A judge is not present. These days, Crown pretrials happen over Zoom, over the phone, or even over email. The whole point of a Crown pretrial is to try and resolve the charges and negotiate with the Crown. Many things can be discussed in a Crown pretrial, including issues that could be raised on trial, the Crown's position, alternatives to proceeding to trial, missing disclosure, and trial estimates. These are some of the more common things that are discussed at a Crown pretrial. It should also be noted that Crown pretrials can typically only be done if the accused person is represented by a lawyer. Crowns are not usually able to conduct Crown pretrials with accused persons who are self-represented. If someone is proceeding self-represented, they have what's called a judicial pretrial, which is very similar to a Crown pretrial, except it is in front of a judge. Next, I will discuss some important dates that an accused person will have during their criminal proceeding. If a matter does not resolve at the Crown pretrial or judicial pretrial, it goes to a trial. For matters that are more serious, they will have a preliminary inquiry before proceeding to a trial. And preliminary inquiries determine if the Crown has enough evidence to proceed with a trial. A trial is a process whereby a judge or a jury determines if someone is guilty or not guilty. After hearing the evidence, either the judge or the jury must decide if the Crown has proven the accused is guilty beyond a reasonable doubt. This means that if the judge or the jury has any reasonable doubt that someone did not commit the offense, then they must find the accused person not guilty. Trials can be time-consuming, expensive, and complex. The Crown and the defense call witnesses and present evidence and arguments to support their case. An accused person has the right to remain silent and does not need to testify at trial. There are many factors that impact the duration of a criminal matter. For example, different courthouses have different backlogs, and the nature of the charges can also impact how long a criminal matter takes. An accused person does have the right to be tried within a reasonable time. It is important to note that regardless of the charges, many of them can take several months to resolve, so patience, self-care, and a strong support system, whether they are personal relationships or through community organizations, are critical. Clients who contact the Schleifer Clinic are usually charged with assault or assault with a weapon. This is also usually the first time these individuals have ever been charged criminally. The most common resolutions offered by the Crown are PARs and peace bonds. These will be discussed in detail in other modules. It is also important to note that just because these are common resolutions that we see at the clinic, this does not mean that this is how your criminal matter will resolve. Every resolution is dependent on the facts, and outcomes are different for different people. The information provided in this workshop is not legal advice, but information only. This workshop will provide general information and is not meant to be used for specific legal matters. Please consult with a lawyer if you have questions about your specific legal matter. Also, due to the constantly changing nature of the law, the Barbara Schleifer Clinic cannot guarantee the legal accuracy of this information outside of March 2023. That concludes this webinar. Thank you for listening, and if you have any questions about the Criminalization of Women project, please contact the clinic.